How can a criminal defense lawyer convince a prosecutor to dismiss a case after it's been filed? Hi, Stefano Molea, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. In this video, I want to discuss a strategy in convincing a prosecutor to dismiss charges that have already been filed. And now some people might think, if they reviewed the case and decided to file it, what makes you think that the prosecution will then dismiss it? Wouldn't that be sort of like an admission that they did something wrong? Not necessarily. First, let's talk about the review process for a prosecutor. They get a case, they review the evidence available at the time, and if everything looks good and they have a good faith belief that they can prove the case beyond a reasonable doubt, then they file the charges. But things change. Many times, not every single piece of evidence is available to the prosecutor at the time the charging decision is made. Other times, a criminal defense lawyer will provide evidence that law enforcement didn't know existed or neglected to uncover or collect. Or maybe the criminal defense lawyer will describe a scenario to create enough reasonable doubt to get the prosecutor to drop the case, give that prosecutor a different perspective. For example, in a self-defense case, there may be credibility issues that I uncover that make my client's account more believable than the complaining witness. Or I explain how a legal principle maybe afforded my client the ability to use force against the complaining witness. Let's say in an attempt to recover property in a particular situation. So you can see that with the thorough review of the evidence and investigation, the dynamic of the case can change to the point where the prosecutor can be convinced that they no longer are able to prove the case beyond a reasonable doubt. Now, some may be thinking, why try to convince them? Just take it to trial. Sure, that is an option, but there are other factors that must be assessed by the client. Look, the point is to discuss the different strategies with the client so that they can make an informed decision about how to move forward. Sometimes it might be to take it to trial and win. Other times to try and get it dismissed ahead of time. Hope this was helpful. If you have any questions, give me a call. Stefano Molea, San Diego criminal defense lawyer, 619-295-3555.